Hey there, everyone. It's Rob Ryder. Today, we're going to talk about property tax and taking it personal. And really, what that means is you got to start by reading the damn paper, right? Read the paper, whatever they sent you. Don't not take it. Don't act like it didn't happen. Read it and then take action. And so, hint, one of the things we're going to see is, well, what is the legal description of the taxed property? Because at the end of the day, you're going to pay your taxes, but don't pay anybody else's. So paying your taxes, not others. And if we were to do that and say, okay, I'll pay my taxes on the property that I purchased instead of the property that you're taxing, well, you may not pay such a high tax. But because you agree to pay that tax, well, there you are. You're stuck with it until you change it, because they're not going to change it. They are okay with the system. If you want to change your position on property taxes, you're going to have to do it. And so that's what we're going to do. We're going to read some papers and then get an idea of, well, what might you do to take action? And put that to use next week. Go ask some questions. But what this really all has to do with is the relationship between the county and your local municipality, be it a township or city or village or whatever it is, because the left hand apparently doesn't know what the right hand is doing. That's their excuse. And we'll see if we can take their excuses away, if they will put your name in the book saying that you're the owner, and what the address is of the property being taxed. So this is Sunday, March 31st, 2019. Rob Ryder, that's my avatar. My email address is courtofrecord@aol.com. No S's on the ends. COURTOFRECORD@AOL.com. Phone number 616-712-6179. I can't always talk to everybody, I'm sorry to say. Hey, if you can, though, please donate, especially if you're going to call. PayPal account, robryder@aol.com. Or credit card or debit, you could send an email, inform me of your donation amount, and I can send you a money request via PayPal for that amount. And make it quite simple. Hey, you could use the mail. Robert Allen Ratlewski, 10955 14 Mile Road Northeast, Rockford, Michigan, 49341-8664. And you should all keep in mind that I don't own any property, right? This isn't doing me personally any good whatsoever. I don't pay property tax. I pay rent. But this is, working for the common good. It's what we do. And why did I put this on there? Oh, here's just one of those little pieces of law. This is from Illinois, where it says classification of property. Where property is classified for purposes of taxation in accordance with Section 4 of Article 9 of the Constitution, and with such other limitations as may be prescribed by law, the classification must be established by ordinance of the county board. If not so established, the classification is void. In just a second, I'll show you what that means. But I need to load up some papers. So, hey, let's get started. If you own property, right, you're going to want to pay attention, because somehow this will all tie to how they do it in your particular venue, but it isn't the same all over. So I'm going to show you something about Michigan, something about Wisconsin, something about Illinois. Bobby in Arizona right now is looking to see how they do it there. We'll have some more on that. But this comes down to you, if you own the property, getting out of your chair and going and talking to them that are taxing you to find out, well, why are you taxing me for property that I don't own? Because they're not using your proper legal description. And other little Scrivener errors in the records that if you don't fix the errors, well, then everybody assumes that must be correct. You haven't come to fix them. It may have been done in deceit, but it was done, and now we have it. And if you want to undo it, well, right, you're your own savior. That's how we get it done. Okay, I'll be right back. Hang on just a second here. Okay, so there really isn't any order to how I'm going to do this. I'm just going to be showing you different bits of information from these few different states and compare it to people's paperwork for those states and say, well, based on the evidence, you should go ask this person this question and see what they give you for an answer. But when they try not to answer, or they don't answer your question directly, right? Let the yea be yea, let the nay be nay, otherwise it's a lie. You need to ask the question again. Say, you didn't answer my question. And try to get some answers out of them. Because once you get past their first, denial, they start to give up with little details. Like, well, you need to go to the Register of Deeds office. Or, some little blurb comes out of their mouth that it may not be a complete answer, but it's more than we knew before. And someday we'll know enough to ask another question to even get more information, and we'll figure it out. But they're not going to tell us because the whole system has been compartmentalized. Not everybody knows what's going on. And I'm going to show you evidence of that as we go on. So for our first evidence, let's look at this section here from Illinois where it says, this classification of property, unless it's established by ordinance of the county board, the classification is void. Well, let's look at an example. Kane County property tax inquiry. All right, this is Rosita's property. And, what does it say? It's got a parcel number, a site address, the owners. Now, see, the owners' names are backwards, and they got commas in them. Well, even if you put my name backwards, it doesn't have a comma in it. It doesn't have a comma in it frontwards. You're not going to put one in backwards. If it's supposed to be my name, then make it my name. And this is one of the things that Rosita complained about, because this name here, where they are the proper direction, it used to be backwards also. And she complained to this is to the county assessor's office, who changed this one. But he said, well, for me to change this one, he said, I can't change this one. It'll crash the system unless you can get the judge to issue an order. Or he said you have to go to the court to have him issue an order. Well, we haven't really done that yet, right? But that's what he said. Now, because of the last video I did about this thing about the writ of right, right, that's what a civil action is. If you were to look at the civil procedures for your courts, it'll say there's one form of action, a civil action. Well, then what is a civil action? As it turns out, I showed in my last video, civil action is a petition demanding a right. So you have a right to have your name properly done because you're the owner. So go petition the court, right? But you don't do it with all their papers, all their forms. It's a petition to the court. And so how exactly that's done, I'm trying to figure out right now. But it doesn't change the fact that a civil action is a petition. That's what the thing needs to be called. You need to be called a petitioner. And the person you're trying to get an answer from needs to be called the respondent. It's a form of action. Anyways, right, so that's what, we might try in her case is petition the court to get this name changed. But that's just one of the things that's wrong. It also has this property class. Well, as it turns out in Illinois, they have a manual, so I believe you're probably going to find this for any jurisdiction, the township assessor's manual, or whatever the local assessor is, right? They're going to have a manual. This is a smaller jurisdiction than the county, however they did your state. Illinois is the townships. So here's the assessor's manual. You can find all this shit online, right? So, in here, it talked about classification, the practice of classifying various types of property according to the use and assigning different assessment levels to each class. The purpose is to tax various kinds of property at different effective rates through the nominal rate, though the nominal rate is the same. So, what are the two classifications of property? That's what they were asking in this manual. As you can see, I was just searching on the word classification. And I said classification of property, page 82. There was something about classification of property, but this is what I'm looking This is the one I read, right? Classification of property, where property is classified for purposes of taxation in accordance with Section 4, Article 9 of the Constitution, in which such other limitations as may be prescribed by law. The classification must be established by ordinance of the county board. If not so established, the classification is void. The CDU is broken down into 5 classifications. Well, what's CDU? Well, that's the rate of depreciation. That wasn't it. Here it was. Finally, just by searching this word, you saw before this was a blank. There are 2 classifications of property: real and personal. Right? So in Illinois, there are 2 classifications of property: real and personal. But when you look at this property class, this says it's 0040, residential improved lot. Well, that doesn't say real or personal. So they made up this class, which means this has to have been done by an ordinance. And if it was done by an ordinance, they're going to have to show it to you. And if they can't show it to you, well, then it's void. And that isn't your classification. So you don't have to pay the tax that this classification is tied to. Because this property class is going to have, some formula for figuring out the taxes. Well, they made it up. Okay, do they have the authority to have done so? But let's continue on. There's other things on here, right? Acres, 0.0000, right? They're not taxing the land. Mailing address, there isn't one, right? So where's the mailing address? You mean you're not mailing this bill to the owner? Then what is it you're sending them? There should be a mailing address here, right? Because this is owner's name and address, but that isn't necessarily the mailing address. It's one of those questions they ask you on forums, right? If the mailing address is different, put it here. And then finally, it has this legal description, which this legal description is nothing like we'll just do it right now. Rosita's warranty deed. All right, so here's the warranty deed for the property that Rosita and her husband bought. And what happened here? There we go. So it's lot 162 of Unit 6, Cambridge East, St. Charles, Kane County, Illinois, in the city of St. Charles, Kane County, Illinois, right? That is her legal description that she believes that she purchased. Let's see if that matches what's on the tax thing. Well, no, it's not even close. Right? First of all, the lot is at the end. It should have been at the beginning. And this isn't nearly the same length, and it isn't the same words. And well, this isn't the legal description that Rosita purchased. I don't see how you can argue with that. Lot 162 of Unit 6, Cambridge East, St. Charles, Kane County, Illinois. Right? Not County of Kane, State of Illinois. No, Kane County, Illinois. In the city of St. Charles, Kane County, Illinois. That's the legal description. That's what you need to tax her on. Or you're simulating a legal process under color of law and violating her civil rights. And so now as we're finding out, these are things that under the D.C. Code in the District of Columbia, because actually we're all found in the District of Columbia, you can go to the United States District Court for the District of Columbia and file for a quo warranto against a state official, city or state or federal. I don't know how we're going to use that yet, but it just came to mind, right? That, hey, this is the address I bought. If you're going to try to charge me for this address, I'm going to have you arrested. Right? So instead of that happening, let's fix the records and leave me in peace. Because this thing is all wrong. Don't have that property class, doesn't have a mailing address, got their name backwards. so forth and so on. And see, this one has a site address. And I'm going to show you in a minute that on Terry's in Wisconsin, on her record for site address, there isn't like the St. Charles, Illinois line. Well, let's just look at it right now. Right? They only put half of it on there. Site address. That's wrong. And her municipality is the town of Milton. So now this is Wisconsin. And Wisconsin, you go to your county, you can look at the tax database, right? So this is from the treasurer's office in Wisconsin, where this one is from I want to say it's the assessor's office in Wisconsin and Illinois. So I don't know if there's a separate one for the treasurer yet in Illinois or not. But my point is, you need to look at these documents closer and point out the errors and go down and say, hey, this is wrong. We need to fix it. Who do I need to talk to? And, so again, I'm just going to add this in now so I don't forget. I think one of the main players in this is one that gets overlooked in all of these things where people are going to the county and so forth to try to get things done in a court case or whatever, is you have a district county commissioner, and that commissioner sits together with the other district county commissioners and forms like your county's, board of commissioners. And when they're all formed together, they're wearing one hat as a legislative body called the, county commissioners. But when they sit separately in their own offices, they're a district commissioner in the county. Or they're a county commissioner over a district, however you want to look at it. But what they are is they have a different hat on. Now they have their administrative hat. They're actually a justice of the peace. And I think you take it to them, they go to a different court, not the one that we think of as the circuit court or the court of record, right? But to the probate court, which is really the court of record because that's where all the records are. And in the court of record, right, what matters is what the record says. It isn't that they write all this stuff down and they make a recording. No. Let's go to the file, pull the record out, see what it says. Whatever that says, that's what the law is going to go with. That's how common law works. It works by the record. So we need to change the record, right? This is a record. This record has errors. We need to fix the record. You're going to go talk to these people. They're not going to have ever heard somebody tell them this before, and they're going to, freak out a bit. They're going to give you the half answer they've been given to give people for an answer. What we need to do is not get upset about it and, say, well, but you didn't answer my question. And that's what Terry did, right? When her first time around trying to find out why this only had one line for her site address, she went to the Register of Deeds office, to the tax office, to the town of Milton office, to God, I don't know who else it was. But it ended up being that it was somebody in the county who finally fessed up that they're the ones that put this address in this block. Because all of these are coming from different databases, right? Like, this is just information in different databases pulled together and put on a form. The other thing is there's no volume and page number. And this is supposed to have to do with a survey. So again, there's no land, right? There's no survey on here. Just like on Rosita's, there's no acres. There's no land involved in this thing. Then why am I paying a tax on it? And who told you could put a freaking comma in my name? I don't accept that. Right? And if they tell you that you need to go get then you're going to have to get a court order. Tell them, well, no, you need to get a court order. I told you it's wrong. Go fix it. See if that works better. Right? Tax rate, unavailable. They can't tell you how they're taxing it. It's just made up. So, this is the part about looking at these forms. And so then one other one. Let's start here. All right, Kent County, you can go to the parcel viewer because what we're talking about are parcels, right? So you can go to Michigan. They got a parcel viewer. If you put in your county name and put in parcel viewer or something, hey, you may end up with a page like this. You put in an address. It's showing you a dot piece of property. It's got the owner's name. Well, that's backwards. Property address. Well, On the warranty deed, the property address would have the frickin' city, state, and the zip code on there. It wouldn't just be one line, right? This is really the same as this. It's an incomplete address. Yet that's what they did, right? Property, state, MI 49341. Zip code, there isn't one. It's done on purpose. This isn't errors. Well, they're errors. They're mistakes as far as we're concerned. They're omissions, right? But it was done on purpose. There is no zip code, and the property state is MI 49341. And the property address isn't in, the United States. This should probably say Oakfield Township, or at least Oakfield, Michigan, 49341. That's what the property is. What's the site address? Right? This is the site address. But hey, you can click on that button there on the PIN number, and it'll take you to the parcel identification. And so there's the parcel number, the government unit, right? It's in a township. The name of the owner, nope, it's backwards. That's not. It should be Norman, middle name Davidson, not Davidson Norman. The address. Now, as we're going to see in Michigan, hey, property classifications, they have it as 401 residential. Well, there's a number of residential classifications in Michigan, and 401 is residential real property. But classification 451 is residential personal property. And you don't pay property tax on personal property in Michigan. Not if it's residential. It's not taxable. And so what they did is they gave everybody 401. But you can go down to the local, whomever is responsible for that number and say, look, I don't want it 401, I want it 451. How do we change it? And, you could call that a change of use. They got a form to do it, $40, change of use. Fill it out, put it in, and tell them you want to change it to 451. Right, but right now they're all 401s. If you live in Michigan, look at your property classification. It's 401, unless it's business or, industrial, farming, or these other ones. Because on these other classifications, if it's personal property, you do pay tax, but not on residential 451. I'll show you that in just a second. So, okay, that's kind of the first round of, where you would go to start to see what it is you need to see for you, right? One place is, well, look at your tax bill. Well, no, this isn't the tax bill. Here, let's look at the tax bill. This is the assessment record, and here's a tax bill. All right, so when they send this, they're going to send it to names backwards with commas. Right? Well, that isn't your name, so it really isn't your bill. And this thing had information on it too. All right, so here's all the things you're paying tax on. These are all these different districts that they're saying you're in because you've agreed to be your name backwards with commas. In fact, Avarius, he don't have a comma. See, only Rosita has a comma. I think on the other one, they both had commas. Maybe not. Tax code, acres, right? You're paying tax on nothing, on air. Hello? You want to pay $6,000 for air? Polluted air? We need to have a talk with somebody. This just ain't quite right. Let's see, do they got a classification on here? Let's see what your classification is. Equalize, senior. Right? Now, remember on this other one, they couldn't tell you what your tax rate, unknown. Right? We don't know what your tax rate is. There's no idea, apparently, but hey, we're going to issue a tax bill. for $7,000, well, 6,000 and change. Right, without knowing what the rate is. You would think those are things that you could complain to somebody about, starting with your local assessor, because they appear to be using different information. Okay, give me just a second again. Okay, so just a couple more things on, this is in Wisconsin, right? That you find by using the parcel details or the address or so forth. But you see, it's got this parcel detail, 026061014, and it has a parcel number, 613-983. Well, they can't seem to find any record for this. They just keep telling us that they're just incorporated with each other. But the municipality says Town of Milton, right? So it isn't where the address for Terry is, right? The site address isn't where Terry is. The site address is 1734 East Road 4. You know, it should probably say Milton, Wisconsin with some zip code. It's got a section town range. It's got the school district, other tax codes, documents, but no volume and page. And this, she was told, is where the survey would go. And then at the bottom, it gives the legal information, right? That apparently that's the address that they're taxing. But, you know, when you look at Terry's warranty deed, it says Lot 14, Block 10, Mallwood Estate, Township of Milton, County of Rock, State of Wisconsin. Right? Lot 14, Block 10. Is that where we started at? No, we started at PTSE 14, Maplewood Estates, Lot 14, Block 10. In other words, these two legal descriptions are not the same. And I'm saying, look, you only own one or the other, unless they're going to show you you own both. And to do that, they'd have to be in your full legal name with your proper address and all the blocks filled out. Otherwise, you say, well, it isn't mine. I'm not paying that freaking tax. And so, you know, they can't do that to you. But they are. This is what they're doing. There's errors in the records, and we're not going to the right offices to get them fixed. And people that have gone to these offices, you know, they get a dumbass answer to their question, they get upset and they leave. Well, then they win. We can't do that. We got to go back and ask the question again. You got to be a rock. Be the rock. Okay. Let's spend some time looking at Dana's stuff because he's got a lot of interesting pieces of paper. So here's one of them love letters that come to you at some point if you can't pay your taxes, right? And certified mail. What does that say up in there? Kalkaska County Treasurer with the 5-digit zip code address. And then down here in this window, this, which ends up being a type of a parcel number, for Smith Dana R. Right? 4460 Blue Lake, Kalkaska, Michigan, 49646 dash and nothing behind it. Well, Smith Dana R didn't buy anything, right? His name isn't on the warranty deed. And as we're going to see, this isn't a complete address. It should say Road Northeast with the +4 if it's going to be his address. And so, you know, really this is using the mails for violation 18 USC 1341 and 42, fraud and swindles and fictitious names and addresses. They certified mail to a fictitious name and address and it got delivered. I'd have to question that. And we will. But let's see what's going on in Michigan here. So give me just 1 second again. Okay, so you take that out of the envelope and you end up with a piece of paper that looks like this, which was a come on, man. Kalkaska County notice of forfeiture. All right, so here's the stuff that was showing through the envelope. And it said Kalkaska County notice of forfeiture. Kalkaska County Treasurer, right, phone number and so forth. And this is the proper seal for Kalkaska County, right? It says Kalkaska County, Michigan. So it's like, well, this is the proper office, but this isn't the right information. And it's not a mailing address because it doesn't have the mailing address on here. It's an incomplete address. But there's that number again, 002-034-00500. And here's a legal description for that property. But when we look at Dana's deed, right, this is what he bought. So there's that, right, north 1/2 of the northwest 1/4 of da-da-da, Okay, that all looks good. Until they get this part includes. Well, that isn't what his says. It doesn't include that. All right, so what is it that they're taxing him for? What's this additional stuff that's on here? You know, why are they saying that it's his tax? Right, property address. Now it's got Road Northeast on it. It's the same address. Smith Dana R. Right, supposed to be the owner. Property address. But that isn't the address that they're using. This is really, I mean, this is a crime. It's a fictitious name or address. And there it is again. So the question was, well, what the hell is this number right here? Right? And this number here, is that what showed up? I need to go find it. That's going to take me a second, so hang on one more time. Okay, so after Dana got that love letter, it's like, well, Dana, let's go down to the local assessor and see what information he has, because they're taxing you for something that's not on your warranty deed. And he got these papers from the local assessor. So, you know, in Michigan, it's a township assessor. And there may be an assessor that does more than one township, but you get a hold of them through your township office. And, you know, this is like the property cards that the township has on your property. Now, here it says property address, right? And it doesn't give the second line. So that's not an address. That's not the site address. There's no grantor or grantee listed, which means, you know, Dana isn't the owner because there's no grantee. I'm sure there's other errors on this page, but this isn't even really the page I wanted to look at. It just happened to be one of the pages. It was this one, which is the second page, I guess, of the bundle, but it says building 1 of 1, and it's got a parcel number at the top. Right, and so Dana took this number and called the Register of Deeds. Well, let's just finish up here real quick. So Dana's getting all this from his township assessor, and then asked some questions after getting it, and you know, getting a chance to think about, well, what to ask the guy. And hang on just a second. Okay, so anyways, after getting these papers and finding some things to ask the local assessor about, what he gave up is that, well, all the books for the township are in the county at the Register of Deeds office. And so Dana took that parcel number and called the Register of Deeds, and they said, yeah, we have information on it. And he went up to get that. We'll get to that in a minute. But this is still the stuff that he got from the township assessor, right, with that parcel number on it. That doesn't show a grantor or a grantee. Verified by WD, which I guess is a warranty deed, but it doesn't say so. You know, it says warranty deed here. Now, what does WD mean? Right? Class, residential, zoning. They don't have any zoning in there. It's not zoned for anything. right? This is at the local assessor's office. This is what he's using to assess the tax. It's not tied to any map. Well, how can that be? Right? It's supposed to be the ground. It's tied to a map. If it isn't tied to a map, we're not talking the land. Tax description. Right? This is all the blah 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 that was on the on his well, yeah, maybe it isn't. That was on his tax bill. So here's the tax description. See here it says section 34 T28N R5W. I don't believe that's on his tax bill. I don't. This is the thing. How much stuff can you find every time you look at their paperwork? Oh, yeah, it is. Okay. T28R5W. It is on there. Anyways, they say this is the legal description on this one. On this other one, they say it's the tax description. I believe this is the one that calls it the tax description. It's got the same thing. Yeah. 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 Okay. So many pieces of paper to remember where they are. Where is this one? That was this one. Okay, but anyways, there is no zoning on here. Although on the bill it said it was zoned 401. It's 3.3 acres, da 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 da. Okay, so that's that page. What else was there? Then there was this page, which got the parcel number at the top. This must be like a second page. I don't know on here if it says zoned as 401 or not. Right, these are just all the attributes of the property. All right. There's that one again. All right, class 401. Okay, this is State Tax Commission residential. Well, let's think about this now. This is the State Tax Commission, and as far as they're concerned, well, nobody owns the property. It's vacant. There's no grantor or grantee. It's never been transferred. This isn't using the same address now, right? You can see, or the same legal description as the other ones we looked at. I had that other blah, blah, blah with these, what are supposed to be parcel numbers. And now they've added 40 in front of the parcel number that the local zoning is using, right? Because this is from the state tax commission. Where this other one is like local zoning. Good. Which one do I want? This one. Okay, so this is Blue Lake Township. No grantor or grantee has a tax description that includes these other parcels 002, 034, 00501, and 002, 034, 005, 15, which were actually two splits that were put together to make this number, this parcel number we have today, which is 002, 034, 00500. Except, right, this is the township. When you go to the state, well, it has 40 in front of it, right, which stands for the county. 40 is Kalkaska County in Michigan. But there's no grantor or grantee. And, here's the description they're using, and it's not the same. It doesn't have those parcel numbers on there. So this is the State Tax Commission. Why are they using a different description, a different parcel? Saying it's class 401, so forth and so on. How come these records don't match? Well, the person that knows, or should know, right, is the local assessor. And if he doesn't know, well, then the county assessor. And if they don't know, well, then the treasurer. The treasurer doesn't know, well, then the county commissioner. Or, I mean, the register of deeds. But they're all going to be pointing their fingers at each other. So my point is, well, get your district commissioner for the county, show him, and have him go get it fixed. That's what he's there for. He's your administrative arm of the state locally. And so where the township supervisors used to be justices of the peace in Michigan, back when they went to the county commissioner system in the late 60s, right, they got rid of all justices of the peace in Michigan, which means, well, now the township supervisor is no longer a justice of the peace. And what they have instead are commissioners, which, you know, they have the same powers as a justice of the peace. It's just a different name. Somebody with administrative authority from the state, representing the state locally. I'm saying that's our point person, right? That, yeah, we can go to the township and talk to them because they're even closer, but that's where your district commissioner should be working out of for you is out of your township hall. And if he's got more than one township under him, well, then he would go to the other township hall to take care of their business. But these records are wrong. Okay. Now, one of the other papers that Dana got from the township assessor, right, so the local assessor, is this page, which is like it's out of a book because it's page 57 of 59, Blue Lake Township, 002, section 34, page 57 of 59. Well, what is it? There's 36 sections in a book, or there's 36 sections in a township. So, yeah, 34 would be on 57, 35, 36. Get you to page 59. So, what this showed, right, this was done back in 2010, so it's of 2010. They colored this in and said what it was, and, you know, they gave it to Dana. This is what the township said was his property, 3.3 acres, Dana Smith. Well, as we'll see, this isn't, you know, like by the laws and the property. There should be there should be an assessment roll, is one of the things that he should have gotten from them. But in this one, as you can see, there's nobody's name in any of these boxes. So when Dana gave this, what ended up being his parcel number, 002034, and then 00050, and gave it to the Register of Deeds. The Register of Deeds, sure enough, they have information on that parcel number, right? Because this is from Kalkaska County Net. Says what the jurisdiction is. Yeah, there's the owner's name backwards with the property address and owner's address. Now the property address has got the second line, but on those other documents it didn't have the second line. So, you know, as you can see, there's errors in records all over the place. And the way to fix your problem is to get the frickin' errors out of your records. And they have to do it because they're errors. And, you know, this is using its version of a tax description, but that's not the tax description that the state of Michigan was using. All right, they stop at 100 feet thereof, section 34. Can't read that, 28-5, I guess. Which is even yet a still different way of saying the same thing. On this right here. And so, Register of Deeds got errors, local township assessor has errors, the state has errors, errors. But what they did have on the wall at the Register of Deeds is a section map. They didn't have a book, right? This one comes out of a book. Well, they ain't got that book at the Register of Deeds, but they do have these maps. And on these maps, every one of them has a name in it. It's all penciled in. Right? Dana Smith is in his box. All these people are in their boxes. But in the township, nobody's in their boxes. So the evidence is overwhelming that, things aren't the same. And this is my point. I'm just trying to hammer into your head. You're correct, right? You just need to stay there and make them agree you're correct. You need them to acknowledge that you're right, that there's errors in the records, and that somebody can fix them. Now, who's the somebody? And let's get them fixed. Right? But if you're going to the treasurer and the treasurer's errors are incorrect, you shouldn't have to go find out why. The treasurer has to. You're telling the treasurer those are incorrect. Go find the records. They're not going to want to hear it, obviously, and they're going to do everything they can to make you get away because, hey, this will change the system forever. But, that's the idea. You're trying to change it forever. So, and then it was, as we saw, all these things say that there's what would be a good thing to look at here? The tax notice. Does this say it's R451 or R401? What? No. That's right here. Right, this is what the county has. Parcel number 002-034-00500. You should have 40 in the front of it. That's what the state has. That's for Kalkaska County, but it doesn't. So we'll just go with this. Right? This current property class is 401. So we're going to take a minute and look at these different classes in Michigan in case your state has the same thing. So hang on just a second here. Okay. Sorry about that. I got pulled away for a minute and completely out of the zone. And so I don't really remember where I was. But what I'm going to do is finish with this part. This is really just an introduction to the idea, anyways, that we need to be talking to certain people about these defects that are easy enough to see in the records. But in this case, again, this is what the Register of Deeds, which in some states may be called the county recorder or whatever you call the person that keeps your deeds. In Michigan, it's called the Register of Deeds. That they have identified by this parcel number, which doesn't have the 40, which would identify as Kalkaska County, but just by the parcel number that we've talked about before, they have this information on record. And so this information all came from somewhere, and so since it's wrong, it needs to be corrected. Right? Well, that's what you tell your district commissioner. Dude, this is your fault. You fix it. I don't know who these people are that did this stuff. I go talk to them. They won't help me out, but, you get it fixed. Or you tell your township assessor to tell them to get it fixed. But as I was looking at this, see here it says current property class 401. Please contact the zoning administrator for official zoning information. Well, that's what we need to have. We need to get the zoning information fixed. And, so your township has a township supervisor and a board and a secretary and a clerk and so forth. Well, they also have a zoning office or zoning and planning or whatever the word is, right? And those people have something to do with this classification. And so where in Illinois we had seen, right, that in accordance with this particular section of the Constitution, ordinance of the county board, if not so established, classification is void. Right? And so really there are only, according to Illinois law, there are two classifications of property, real and personal. And in Rose's case, they had some number, personal or real property. It's like, well, is there something from the county saying that that can exist? So in Stephenson County, it looks like, which is in Illinois, well, it looks like they did do one. They got these property classes, and tells what type of property it is. Right? So, Roe doesn't live in Stephenson County. Roe lives in Kane County. Did they do the same? And just because these say that these are what they say they are, is there a county ordinance that goes along with it to say that they are? Right? Because that's what this says. There had to be a county ordinance. Must be established by ordinance of the county board. So only something with a seal on it saying that you created them, or they're just being used illegally and they don't apply to you. Now in Michigan they did a little bit different. They have a list of state tax commission recommended classification codes for all these different classifications of property. Right? You got agricultural and commercial and industrial. And finally you get to residential and timber and utility and exempt, DNR, real. Well, here's 401 residential improved, right? It says it's real property. So it would be taxed as real property. But we got two of them that are not taxed as real property. Residential leasehold and residential personal. Right? And so, well, if they're not real property, why would that make a difference? Well, let's look at, let's see, it says page 32. The Michigan property tax, real and personal. Michigan Department of Treasury, Office of Revenue and Tax Analysis, May 2002. All right, I got it online. The Michigan property tax, real and personal. Google it. I'm sure you'll find it. And on page 32, it showed agricultural and residential personal property are largely exempt from property taxation. See Exhibit 17. Well, here's Exhibit 17, personal property value as percentage of total value. Residential and agricultural, 100%. Apparently what that means is exempt, right? Largely exempt. Well, how largely? Well, 100% largely. But if your property is zoned utility and it's personal, well, then it's 100% taxable. If it's industrial, it's 40% taxable. If it's commercial, it's 23.2% taxable. But if it's residential or agricultural, it's 100% exempt. Right? So you want your property to be residential personal property, and you won't pay any taxes. And according to this code, well, you got two choices to make it personal. Residential leasehold improved or residential personal. And what are these classifications then? Residential personal property classification. For taxes levied before January 1st, 2003, residential personal property includes a home, cottage, or cabin on leased land. Okay, but so basically after 2003, homes, cottages, and cabins on leased land are no longer residential personal property. Well, if your home isn't on leased land, then, it should be residential personal property. Are they going to tell you that your home is on leased land? Because you got a warranty deed saying, well, I bought the property. It's right here. Here's the description. I didn't buy the house. I bought the land. Right? The warranty deed shows I don't know if I have Dana's warranty deed up here still, or quick claim deed. But it shows that he bought the what you would call the public land survey land from the survey. And so it's a matter of getting this thing here. Where is that at? Got too many windows open. This is the same thing. Our homes, cottages, and cabins on leased land to be classified as residential personal property? No. What about homes on fee simple land? Right? Because you believe you bought it in fee. It isn't personal property. Your title insurance will say you were getting it in fee simple. Right? So you have marketable title for fee simple. It's just it's not being classified as personal property. It's being classified as real property. And until you fix it, they're going to leave it the way it is and say, well, come pay your taxes. So it's a system waiting on you, right? You need to go fix it. Nobody else can. And I believe the place that gets fixed is zoning, right? You need to have a zoning change, or you need to do an appeal to the appeals board. But this has got to change right here. This current property class has got to change to 451 or 411. Right, so that you can Google this. If you're in Michigan, Google this too and find it, right? This is just state tax commission recommended classification codes. If you Google that, you should be able to pull this off. And if you do, you should see, well, it can either be a residential leasehold or residential personal, and say, well, it's either one of those. Either it's not on leased land or it is, but either way, it's personal. But you have fee simple title. You're supposed to have. That's what your title insurance says. So, it should be 451. And that's the one we need to make it. And you won't pay taxes anymore. Well, you won't pay ad valorem taxes and so forth. You may still pay taxes because, hey, we got to pay our taxes. You'll just be paying your taxes, not somebody else's taxes. Okay, I want to show one more thing out of the law that goes along with this. So give me a second to load that up. Okay, so every state is going to have their, Property Tax Act. This is the one for Michigan. I'm not saying that everything's the same all over, but I'm saying that the result is the same all over. And so the answers are, in these documents that have errors, seeing what the law says and going to somebody that has something to do with it and say, hey, you're not doing what the law says. And now knowing that we can go to these courts in D.C. according to what they say and, file for written quo warranto against the state officer. That'll be in another video. Well, that's maybe what we'll have to do. But, first we need to get our ducks in a row, get our evidence and proof to take with your petition, if necessary, to the court to have, to get a writ of right. Blackstone will say that is the original, extraordinary relief, a writ of right, which you don't really need to know what your remedy is. They need to. You just need to claim by writ of right that your rights have been violated. And the only one that can violate your rights is the government. And so the king would say, well, I didn't do it. Which one of my ministers made the mistake? Right? We'll get it corrected because, the king wouldn't harm his subjects. He loves his subjects. If there's something happening to you, it's by the clerics that are running the show for the sovereign. Okay, so obviously I'm not going to read a 199-page document, but maybe in yours you can find the same things, like where it says personal property. Right? So in Michigan, if you can make yours personal property, well, then you don't pay any tax. So how does it define personal property? For the purposes of taxation, personal property includes all of the following: all interest owned by individuals in real property, the fee title to which is in the state, is in this state or the United States, except as otherwise provided in this act. for taxes levied before 2003, buildings and improvements located on leased real property, except if the value of the real property is also assessed to the leasee of the owner of the buildings or the improvements. But if you have fee title, okay, and you're supposed to have fee title in Michigan or in the United States, well then it's personal property. It's not real property, or not taxed as real property. Your interest owned in individuals, by individuals in the real property. That's personal property. Can't tax my interest. Okay, and then page 73. What is this? Assessment. Annual assessment of property, right? This thing with the assessment and the assessment rolls is, you know, if you can find your states talking about those, that's what you want to pay attention to, because, you know, the assessment roll is supposed to show who the owner is. Annual assessment of property, and an assessment of all property in the state liable to taxation shall be made annually in all townships, villages, and cities by the applicable assessing officer, as approved in Section 3 of Article 9 of the State Constitution, 1963, and Section 27A. Okay, so your property is supposed to have been done, assessed yearly. Assessment roll and appraisal cards. All property assessment rolls and property appraisal cards shall be available for inspection and copying during customary business hours. So not only is there the card that they gave Dana, there's a roll that they didn't give Dana. Where's the assessment roll? Can't remember if there's, okay, use of official assessor's manual or any manual approved by the State Commission. All assessing officials whose duty it is to assess real or personal property on which real or personal property taxes are levied by any taxing unit of the state shall use only the official assessor's manual or manual approved by the State Tax Commission consistent with the official assessor's manual. So, hey, what manual are you using? Because you can read it too. It's probably online. They probably had the official assessor's manual online for the state of Michigan. Right? Preparation of certified assessment roll. Quality of tax max and appraisal records. Levy on interim term taxes. Substitution of latest complete assessment roll. If a local assessing district does not have an assessment roll that has been certified by the qualified certifying assessing officer, or if the certified assessor or the board of review for a local taxing collecting unit is not in substantial compliance with the provisions of this act, the State Commission shall assume jurisdiction over the assessment roll and provide the preparation of a certified roll. So where's this certified roll they're talking about, right? If your local assessing officer doesn't have one, then the state's supposed to have it. If a certified assessment roll cannot be provided in sufficient time for summer tax levy, the Commission shall order the levy of interim taxes based on a tentative taxable value of individual properties as determined by the Commission. And so this is probably what they're doing. They don't have a certified assessment roll, so they're just levying by interim taxes because no one stepped forward to, challenge the assessment. They may have gone to argue, but they didn't go with the law. Right? Don't go with the law, don't go to argue, go show them the law and say, you're not following this law. That's kind of how I see it. Let's see what we got going here. Assessment, how made? Statement as to assessable property. A supervisor or other assessing officer, as soon as possible after entering the duties of his or her office, or as required under the provisions of any charter that makes special provisions for the assessment of property, shall ascertain the taxable property in his or her assessing district, the person to whom it should be assessed, and that person's residence. Well, that's going to be the assessment roll, right? And you want to be on the assessment roll in your full legal name with your residence address so that you're acknowledged by the assessor. So except as otherwise provided in some other sections, the supervisor or the assessing officer shall require any person whom he or she believes to have personal property in their possession to make a statement of all the personal property of the person, whether owned by that person or held for the use of another. So you need to tell the assessing officer, which isn't the, used to be, it was the township supervisor, but they lost those powers too, and now they have these certified assessing officers. You need to tell them it's personal property, right? It's residential 451. It's not residential 401, right? You shall make them aware. Okay, right? It's not that hard. Let's go down and talk to them. Property assessment roll, time, use of computerized database system. Pay attention now. On or before the first Monday in March in each year, the assessor shall make and complete an assessment roll upon which he or she shall set down all of the following. Right? So there's a thing called the assessment roll. So what would you be doing? Well, you'd be copying this section out of this manual and going down and talking to the assessor. You say, it says right here that you got an assessment roll. You had to have it ready by the first Monday of March. And hey, it's the last day of the month. Where's it at? So what's supposed to be on it? The name and address of every person liable to be taxed in the local taxing collecting unit with a full description of all the real property liable to be taxed. If the name of the owner or occupant of any tract or parcel of real property is known, the assessor shall enter the name and address of the owner or occupant opposite the description of the property. So where's the assessment roll? Not, a map, not some other document. No, it better say assessment roll on it because it's going to have to be certified. I mean, have an affidavit attached to it at some point. So where is the certified assessment roll? Because in there, next to your parcel, it's going to have the name of the owner and the owner and the address of the owner. And if it doesn't, well, then there's a problem. If unknown, the real property described upon the roll shall be assessed as owner unknown. Well, that would be like being abandoned, like why there's no grantor or grantee on the property card. Because the owner's unknown, according to them. All contiguous subdivisions of any section that are owned by one person, firm, corporation, or other legal entity, and all unapproved lots, any block owned by one person, firm, shall be assessed as one parcel unless demand in writing is made by the owner and occupant to do it separately. Okay, so they had it under one number. It is not necessary for an assessment roll to specify quantity of land in any town, city, or village lot. Set the assessed value down opposite the parcel. Right, so you'd have to read this closer, but all these are things that are supposed to be done. Okay, got it. Subject to this section, local tax collecting unit may use a computerized database system as assessment roll described in this section. Now, who's the local tax collecting unit? I believe that that's the county treasurer. It's either the county treasurer or it's the township treasurer. Somebody's doing the collecting, not the assessing. The assessing is done by the assessor. He sends it to the collector to be collected, which could be him after it goes to the board. But it's a different, it's not the same book. That may be the tax collecting book, but it's not the assessment. And you want to see this local assessment roll. The local tax collecting unit shall certify and maintain a retention policy that complies with requirements of something or other. So what are they going to? The assessor shall certify the assessment roll. So let's start there. The assessor shall certify the assessment roll and maintain a computer printed format or a disk external drive, or other electronic data processing format compatible with computer systems used by local tax collecting unit, the affidavit attached to the or included with the assessment roll shall include documentation that the assessment roll has been backed up through the computer system, The local tax collecting unit shall certify and maintain a retention policy that complies with, right, we're talking about that roll. An assessor or local taxing collecting unit that provides a computer terminal for public viewing of assessment roll is considered as having the assessment roll available for public inspection. So you need to ask, well, where's the computer terminal for looking at the certified assessment roll? Right? And if you go do that, take a printout and send it to me, right? So I can see what it looks like, because I don't have anything to go look at. If at any time the tax commission believes the local tax collecting unit is no longer in compliance with the subsection, the state tax commission shall provide written notice to the local tax collecting unit. Well, how would the state know? Because you would tell them by getting the evidence and send it to the state tax commission and say the local assessor is not in compliance. Tax rolls, notwithstanding any other provision of this act, a county by resolution of the Board of Supervisors may prepare tax rolls and extend the taxes thereon for cities, townships, and county at the expense of the county or local unit. But that's a tax roll, which is different than the assessment roll. All right, this is created by a county by resolution of the Board of Supervisors may prepare a tax roll. That isn't the assessment roll. So if it don't say, if it says tax roll on it, say, well, I didn't ask for the tax roll. I want the assessment roll. And it's supposed to have been kept in computerized system, and you're supposed to have it available for me. Right? So where is the computer terminal for public viewing of the assessment roll is considered as having the assessment roll available for public inspection? Show that section to the assessor and say, where is it? They'll have to tell you. If they don't tell you, say, well, you didn't answer my question. Where is it? Where is this record I'm supposed to be able to see? What else was there? Description of real property. Description of real property should be section, township, and range, right? 34, township 28 with the range. Not township, range, section, township, range. Right? So in the one case, it started with 002, which was the township. They should have started with 34, which is the section. Section, township, and range. If it isn't in that order, section, township, and range, then they're not giving you the proper legal description. The description of real property township shall be arranged by the following manner. I'm not going to read all these. Real estate index system. The system shall describe real estate by county, township, section, block, or parcel. Okay. So in the one case they did that, it was 40. They said 002, 034, 00500. Well, that would be the complete description, but it had to have the county in there, the 40. And the ones with Dana started with zeros without the 40. So it isn't that the real one doesn't exist. It's just the one you're looking at isn't the real one, because the real one would have the county in it. 40. The numbering system shall be approved by the state tax commission. The assessing office shall establish and maintain cross-index of numbers assigned under the system with complete legal descriptions of the real estate to which numbers relate. The assessing officer shall assign individual index numbers, and assessment rolls, tax rolls, and tax statements shall carry the index numbers and not the legal descriptions, except that both the legal description and the index number shall be shown on tax statements for the first year after this section is effective. And then after that, well, we won't tell you anymore. Indexes established hereunder shall be open to public inspection. So where are these indexes, the real estate indexes, that the assessing officer has, right, that has the county, the township, the section, the block, and parcel, approved by the State Tax Commission, cross-referenced with the complete legal address of the real estate to which the number relates. So you can make sure that it matches your warranty deed, which is the thing that you purchased. The description of personal property on said roll may be made by using the word personal. Okay, so yeah, you want to see the tax roll. You want your property to be declared personal, not real. And we're just about done here. 103. The board of review, right? So every township, city is going to have a board of review, and they need to endorse the assessment roll. So they can't run away from it. Say, hey, where's the board of review? You had to endorse the assessment roll. Where's the assessment roll? They need to show you an assessment roll, not a tax roll. They're not showing you the assessment roll. Say, you're not showing me the assessment roll. Are you telling me you don't have one? Right? Are you, and get them to answer yes or no. Do you have a certified assessment roll? Yes or no. So the point is, right, that this stuff is just so obvious what's happening. And these are just people that put their pants on like you do, right? They're nothing special about them. They're locals they live in the same township you do. They're doing things by custom, the way they've always done it. The guy at the township, he had never seen the book that Dana showed where they showed the map, right, that showed his highlighted in green. They'd never seen that before, right? They have this other type of map that's on the wall that says it's in Township 28. But Dana says it's in Township 2. So without getting any deeper today, the idea is, look, there's lots of errors. There's lots of things to ask questions about on your documents. And that's where you need to start to find out why these things are on there. And it's like anything else. If you ask enough people and take their partial answers and put them together, maybe we get the entire answer. That's what I'm hoping for. But I don't have any property, so I can't just go do this myself. It's going to take somebody with the property to do it. There might have been one more thing I wanted to show you, so hang on just a second. I do want to show that. Okay, one other little piece of legislation. Transcripts and abstracts of records. An act to require county treasurers to furnish transcripts and abstracts of records and fixing the fees to be paid thereof. Transcript and abstract of paper or record, requests, fees, disposition of money, imposition of fees by certain chartered counties, maximum charge per parcel record, electronic copy of records, resale of commercial purposes prohibited, qualified data file defined. And so this is Act 161 of 1895. Right? MCL 48101. And which it says, well, first of all, let's see what this data file has, right? As used in this act, a qualified data file means an electronic data file that includes at least the following information in the record for each parcel of real property in the county for the current tax year. So you want to get a copy of this from the treasurer. And then it should have, A, B, C, D, E, F, G, H, I, J, K, L, M, N, O, P. At least these many things. The taxable value, the equalized value, the assessed value, the past sale data, property classification, property address, parcel identification number, owner name and address, taxpayer name and address, principal residence status, other tax equalization data, special assessment, total millage rate, enumerated millage rate, tax bill amount for winter tax bill amount for summer tax bill. And make sure that whatever they give you is yours. So the maximum charge shall be 25% or 25 cents per parcel, not to exceed $1,500 for each request under this section, if the request is for an electronic copy of records in a qualified data file that is maintained with the county treasurer. A response to a request for an electronic copy of records in a qualified data file shall be transmitted electronically using a format that is documented by open standard organization and that has defined eliminated fields. Well, I guess you just have to ask them for it and see what they send you, but it should be electronic, right? You don't need to go there and ask them for it. Call them up and send them to email you a copy and to send you the bill. Right? 25 cents per parcel record. So give them your parcel number and say, give me the record. And then question everything that's on it based on all the other pieces of paper you have and say, well, these things don't match, or they do match, or whatever it is. Right? Because it's the treasurer that's going to send you a notice and say they're foreclosing on your house for taxes. So where are they getting their information from? Off of this data file. Okay, hey, I'm going to leave it there. I hope I didn't confuse you all. I know that I got kind of disjointed there for a bit, but that's how it goes. You know, at the end of the day, I'm just pointing out the obvious. And if you want to do something with it, well, it's obvious you're going to have to be the one that does. What else could I show you since we're still here and we're not quite done yet? Right, this is that page that almost looks like it's the data file information they're talking about, except it came from the Register of Deeds office. Right, so if you're in Michigan, contact the Register of Deeds, give them your parcel number, and apparently they can poop you out a piece of paper like this. All right, let's just start with this. And then say, well, if there's errors on it, how do I have them corrected? And see what they tell you. If they say, well, I don't know, say, well, can you find out for me? I mean, this is your business, not mine. I see there's errors in my records. How are they corrected? And make them answer you. Don't let them walk away without an answer. If they can't give an answer, say, well, go get your supervisor and ask them how to do it. But here's the thing, current property class, that's got to change. As long as that's in Michigan, as long as that's real property, you're going to pay tax. If it's personal property, you're not going to pay tax. It's 100% exempt. And I believe that in Dana's case, what he had said, that might be worthy of looking at, because he had gotten, here's the warranty deed, or actually the quitclaim deed that Dana got the property under. He got it from his uncle, right? So they didn't do a warranty deed. It was just transfer within the family was the idea. And the main thing is what's on the second page here. That the tax parcel that he got, actually this is the quitclaim deed that the grantee that he got it from. So the grantor was Mary E. Smith, and the grantee was James T. Brown. And eventually, James T. Brown was a grantor who gave it to Dana as a grantee. But when James T. Brown got it as a grantee, this is what he got. Right? Now it says property description provided by grantor. which means, well, it probably should have been provided by a surveyor, not the grantor. But nevertheless, there it is. And on the second page, it says, recorded, return to grantee, send subsequent tax bills to grantee. And they had an attorney who drafted it, but he only did it as a scrivener. So no legal advice, right? He's just doing it as writing the notes. But the tax parcel was 40,002,034,005,00. But that isn't what the parcel number is now. They took the 40 off of it. So in between the time that, and as you can see, it was exempt, transfer exempt, state transfer exempt. This was done in 1998. They were still using it with the 40. When Dana got it afterwards, sometime in the 2000s, they weren't. And in 2003, they did something with the personal property compared to real property, as we saw in what they define as real personal property. When they say what it isn't, it's not a house on leased land. Well, you don't have a house on leased land. You have a house fee simple, on fee simple land. And that should be 451. That should be simple enough to fix. Let's find out. Okay, you all have a great day, and I hope you get something out of this. We'll see you.